I'm Josh Nelson Elder Care Law. Why should you listen to me? We're the largest elder law firm in the state. We've helped over 6,000 families. I'm also the vice chair of the state bar's elder law section. So pretty authoritative and know what I'm talking about. Today, we have people of all different kinds of educational starting points. And so we're going to go anywhere from foundational all the way into detail. I'm definitely going to leave time at the end to answer any questions that you guys have. And of course, if you have questions that you don't feel like asking the group, happy to answer them side by side later. Whenever we jump into it though, if I can use a clicker, we're going to talk about 4 essential documents that everyone needs. Can't walk from the speaker, I always get reverb. Let's try this. The biggest thing that we start with is the advanced directive for healthcare. Does everybody have an advanced directive for healthcare? So this is really important. This is who you're going to nominate to make medical decisions for you in the event that you lose your ability to. What's the hesitance of getting this? The fear that I'm giving away power. You go to your mom or dad and you're like, hey, let's go ahead and get an estate plan in place. Their biggest fear is that you're going to put them in a home. They're going to lose their authority. That's not how this tool works. Whenever we talk about the Advanced Healthcare Directive, in the state of Georgia, it's called that. Everywhere else in the world, it's called a medical power of attorney. Is that a term that more people are familiar with? Yeah. Back in 2012, we used to call it a medical power of attorney too. And then agents or children would have a financial power of attorney and think they could make medical decisions, or have a medical power of attorney and think that they could make financial decisions. And so in all our legislature's wisdom, they said, let's simplify this by calling it something new nobody else has ever heard. And that's the advanced directive for healthcare. The biggest deal here is that it only has one decision maker at a time. And so what do I mean by that? If you have the capacity to make your own medical decisions, you get to. The person that you've authorized is your agent, has no authority. So when do we use this? Usually, if we're incapacitated, we have cognitive impairment, something like dementia or Alzheimer's, or we're in so much pain that we choose not to make our own medical decisions. Has anybody ever go to the ER with like a major headache or after an accident? Maybe you're just a little dazed and confused. And yeah, you could technically make those decisions, but you're like, hey, it'd really do me better if my spouse could make it or my daughter could make it. From the person that gives the authority perspective, it's important to make sure that we're talking them through this so that they don't feel like they're losing power, because this is the scary one. This is the one that people feel is the put me in the home kind of thing. In the state of Georgia, every hospital has this as a statutory form that if you go in for a procedure and they ask you who's been to a surgery or something like that, and they're saying, hey, do you have an advanced healthcare directive? If you say no, they'll give you a quick one right there. If you're taking your mom and dad through some kind of procedure and they don't have this because you tried to have that conversation and you just weren't ever successful, you can get this as you're doing that surgery pre-op. You can get this right there in the hospital. Why do we need it? Sometimes our spouse isn't the person that we want to make medical decisions for us. Especially in a blended family, it can cause family dynamics. A blended family, just to make sure everybody's on the same page, is whenever we have a second marriage and children from a previous relationship. Maybe your daughter or son is a nurse, and you want them to be the ones that are making those decisions. This is how we appoint that. The next tool that we talk about is the durable power of attorney. This is a little different than what we just talked about with the medical power of attorney, because not only can you act, but the person that you nominate as your agent can act too. So you could be sitting at your house and still have full capacity, and you could let your agent go do things on your behalf. What are some things that they can do? They can sign contracts. They can go get money out of your bank account. They can talk with your financial advisor, make trades, stop trades. They can create a trust on your behalf. Can anybody guess what the two things they can't do, no matter what are? They can't change your will. A power of attorney in the state of Georgia cannot change your will. They can change beneficiary designations if you've given them that power, though. So like on your bank account, your normal checking account where your income comes in, you guys should all have what's called T.O.D, or transfer on death, on that account. If you have that, your power of attorney can go change that for you. So what do we need to make sure that we know about this person? That we trust them completely. Sometimes, if you're talking with your parent and they aren't quite ready for you to have this authority, they're going to ask you to do something that I don't recommend. It's called having a springing power of attorney. Has anybody ever heard that term before? Generally, whenever you have a power of attorney, it's effective as soon as it's signed, which means right after your parent signs their part, you could go do things on their behalf. Sometimes, before it comes to a child, attorneys will write in language that says this is only effective if two medical professionals or a judge say that it is. What's the problem with that? Doctors hate lawyers. Why do doctors hate lawyers? Because they got deep pockets and they're afraid we're going to come after them. So how many doctors do you think are going to take on the liability of sitting across from your parent and saying, I'll sign off on her not being able to handle her money, knowing how much liability that comes? It's never going to happen, let alone two of them. And why would you let a judge make that decision if the whole idea of doing this planning is to keep you out of the court system anyway? This is why I don't like springing powers of attorney. You need to make sure that you trust the person and you feel confident with them having the power right away. Because in the case of an emergency, you aren't going to find two doctors, and that judge takes a minimum of 3 to 5 days and costs a lot of money to get their signature on that paper. How do we have a conversation with our parent about this? How do we talk to somebody and make them feel empowered, that they still have their autonomy, but say we want to help? Honestly, you have to go with them and not play games. You have to be blunt and say, I'm looking to be able to help. I want to be able to control things if you couldn't. I don't want to do anything for you right now, but I want to be legally equipped whenever you need me. That honest conversation is going to go a long way. The next tool that we talk about is really talking about a HIPAA release form. You guys have this at all your doctors, and your parents do too. Whenever they go for your new appointment after the year, and they ask you if you change your insurance, and they give you that big packet of stuff to fill out, buried in there is a sheet of paper that says, who can we talk to? The one that you fill out with that doctor is only generally good for that doctor, or if it's like with Kaiser, it's only good inside the Kaiser network. Has anybody here ever traveled? Probably all of us. What happens if it's only good at Kaiser and we go out of state? Nobody can talk to your doctor. Nobody can talk to that ER person. Flip side, I know we're talking about aging parents here, but this is important for your minor kids as they turn into adults too. You got kids or grandkids going off to college, make sure that they're aware that this is important, because all of a sudden you get that call, even as a parent, you can't get the information you need from the hospital. This is not a decision-making tool. This is just a list of people that medical professionals can talk to. Even with all the technology that's out there right now, one of the things that scares me to death is that like an MRI is still transferred on a disc. Say that you had something so tragic that you need to get an MRI taken, you probably aren't great to just go pick that thing up 3 days later, right? Anybody listed on this tool can go get it. you have multiple kids that are trying to share responsibilities. This, you can have all of them be able to go pick it up, talk to them, things like that. Do we think that that's helpful? Helps kind of push down some of the family dynamics? Here's the pro tip, since we have all of you here today. Doctors don't want to talk to you if they aren't getting paid. As a HIPAA authorized person, how do you get to talk to mom's primary care person without just getting all the gatekeepers that the doctor has? Telehealth. It's like the great thing that's happened in the last couple of years. You can schedule a telehealth through Medicare. As long as you three-way call the person that's insured at the beginning of the appointment, the next 15 minutes are covered. Doctors will get on the phone with you if they're getting paid. This is super helpful if your parent lives out of state or you're unable to make their appointments because you're still working. The next tool that we talk about has a lot of confusion around it. Who here knows what a DNR is? A do not resuscitate order. It might surprise you, but in Georgia, we don't actually have those. In Georgia, we call it something else. Does anybody know what we call it? Nobody? A POLST, a PULSE, Physician's Order for Life-Saving Treatment. So in Georgia, if you have something that says DNR on it, do not resuscitate, it is 100% not a legal tool. In Georgia, a lawyer cannot give you a DNR. The P in PULSE stands for physician. So it has to be signed off by a doctor. Why? Most of us don't really want a DNR, and most of our parents don't really want a DNR. What a PULSE in Georgia says is that if you get so sick that your heart stops, your brain stops, you have a heart attack, that EMS, whenever they come, they can't even do CPR. They can't do paddles. You're dead. I'm up here hot and glistening. If I drop dead from a heart attack right now, I swear to God, I want you guys to revive me. Do not kill me. But that's what a DNR says. Even with great modern medicine, if you have a heart attack, but you have a pulse, you're gone. Most people don't want that. The normal standard in Georgia to get one without talking to your doctor or your doctor just being your buddy is you need to be over 88 or suffer from at least mild cognitive impairment or need help with at least 2 activities of daily living. I work with a lot of people that make this decision and it's the right decision for them. This is hard for children to own. Today, I was sitting across from a lady who came in with her daughter. They both had matching hair, literally cut the same way, dyed the same way. I'm surprised they weren't wearing matching shirts. They could finish each other's sentences. And for that daughter to hear that her mom really wanted this was heartbreaking. But her mom had been through a lot of medical procedures lately, and she doesn't want to keep fighting. So it's important that that mom talk to her physician and get this, if that's what she wants. She specifically doesn't want any extra surgeries. She doesn't want to have CPR. She's very religious, and she says if it's her time, she's happy to go meet the Lord. That brought tears to her daughter's eyes, like it would for all of us if we're sitting there hearing our parents say that. I can't do that though, because I'm not a doctor. So what does a lawyer do? It's a little different. This is what most of us want whenever we say we want a DNR. It's called a living will. In the law, we like to confuse terms. So a lot of people think that we're talking about where your stuff goes when you die. That's not what a living will is. That's what's called a last will and testament. A living will says, if I get really, really sick, where I need the help of machinery or advanced medical treatment, such as a feeding tube, a breathing apparatus, If I'm not gonna get better, if I'm gonna be in a vegetative state, because my medical issue is irreversible and will be terminal if they stop that treatment, I still want them to stop that treatment. I want to pass naturally. If you don't make this decision with a living will, the person that is nominated as your advanced healthcare directive agent has the obligation to make this decision. And I say that as obligation because that's what it is. Helping your loved ones, whether it be your spouse or your kids, make this decision before they get to the point that it actually has to be done, takes so much burden off of them. It's not like in the movies where we remove this kind of treatment and you just hear a long beat. If we remove life-sustaining treatment from somebody, they can still live for minutes or hours or sometimes even days. And the amount of guilt that comes from that for an adult child in you guys' shoes is immense. Having your parent make this decision lets you know it's what they wanted, so that you don't have to be put in that spot. You making that for your loved ones puts so much more ease on them. It helps the grieving process. There's a couple versions of this, and I would caution you against two of them. If you find an old one online prior to 2017, it will have a grid that says, if I get cancer, I want this. If I get Parkinson's, I want this. Don't do that one. The problem with that is that the first reaction most people have whenever they get a crazy diagnosis is, what are my options? If you're locked into that grid, or you lock your agent into that grid, they have to follow those instructions. 5 years ago, if you would have marked, if I get cancer, I don't want chemo, you wouldn't be aware that chemo today is massively different than it was even 5 years ago. Those are the things that people just don't keep up with. And so I'd say stay away from that. The other one that people see is it has 3 options on the first page that says, I don't want hydration, I don't want food, and I don't want food or hydration. Everybody always marks, I want hydration, because they don't understand the medical ramification of that. With modern medicine, if we keep you hydrated and hooked up to machines, you will live for almost ever. That's not really what most people want if they're doing this tool. Help guide your family so we aren't doing that. The way that we do it is we ask the people conversationally what they want, and then we make sure that their living will matches it. But we don't go down all those intricacies of hydration because that's a misstep that a lot of people make. Any questions about that? All right. Why did we not talk about a last will? We went through 4 tools and we didn't talk about a last will and testament. You guys have spent your whole life and told you need a will. Why am I up here not talking about that? Because that only controls what happens whenever you die. And we're worried about how do we take care of our loved ones while they're alive. Whenever you pass away, the state has a plan for you no matter what. Even if you don't have a will, part of your stuff goes to your spouse if you have one. If you don't have a spouse, it goes to your kids. That's what most people end up doing anyway. Blended families, again, definitely need a will. But as of July, we have a new tool. In Georgia, we started doing what's called transfer on death deeds. 25 other states have had these for absolute ever. In Georgia, it's just started here in July. What does it do that's different about your deed? For a lot of people, this is going to make what used to be complex planning more simple. But for other people, it's going to complicate things. If you come and talk to an attorney, one of the things that we will absolutely tell you is be very cautious with putting anybody else's names on your assets. If you go talk to your bank teller, they tell you to put your kids on your bank account. Do not do that. They are wrong. Say that I put my daughter on my bank account, and then later on, she gets creditors. And I'm not talking about just Capital One. It could be medical stuff because she doesn't have the health insurance she should have. It could be that she gets divorced and all of a sudden they look at her assets and now all of a sudden my bank account is considered as part of her assets. Now all of a sudden I got a problem. And so this is why elder law attorneys in general are going to tell you, you don't need to put anybody's name on your assets. But people want to avoid a thing called probate. Probate is the legal process of going through the court system to say where somebody who passed away's stuff goes. It takes between 6 and 12 months, and the average fee is 3% of your stuff. So if you have $1 million, it costs you 30 grand. The other issue that you run into with it, though, is that people will specifically avoid probate at the cost of things like taxes. Who's been in their house for more than 5 years? Whenever you bought your house, it was probably worth more than $250,000 less than what it is today if you've owned it for 5 years. You've had a heck of a market rise, right? If it's your house and it's your primary residence, the IRS allows you to sell that house and not pay taxes on it. Anybody that's not a tax nerd never thinks about that, right? But like whenever you go sell your home, you don't generally pay capital gains. The IRS wants every other dollar from you that they can get. Why do they give you that tax break? Because we want to promote homeownership. And so the first $250,000 is considered exempt of your primary residence, or $500,000 if you're married. Anything else in your life where you make $500,000, the IRS is going to take about 40% of that. So let's talk about the common mistake people make with their deed. It's between you and your spouse, or maybe your parents. Dad dies, because statistically dad always dies first, right? Mom's on the deed and didn't have to go through probate whenever dad died, because there were a couple magic words on that deed. It said joint tenants with rights of survivorship. Because mom and dad both lived in that house as their primary residence, if mom sells it, even while she's alive, and it's less than $500,000 a gain, she gets it tax-free still. But let's say that my mom adds me, Josh, onto her deed after my dad dies. Mom passes. I just skipped probate. I feel really good about that. I go to sell mom's house, and the closing attorney gives me a 1099. What do we know about 1099s? All of a sudden, we got to pay tax on something, right? I got to pay tax because I wasn't ever a resident in my mom's house. I don't get that what's called Section 121 step up in basis. So I skipped probate, which may have cost a couple $1,000s, but now I owe the IRS a lot. That's bad planning. That's what happens whenever we do things piecemeal. Whenever we look at TikTok videos and they tell us how to skip probate, they never tell us how to skip the taxes too. And so this is where a lot of people get into problems. After you've already sold the house and gotten that 1099, can you go back retroactively to the IRS and say, oopsies? No, there's no redos, right? The other big deal that we're running into is you've often heard recently that the state of Georgia has changed the way they're dealing with state school tax exemptions. So right now, Cherokee County used to give all the seniors a break on their taxes. So instead of being like $4,000 or $5,000 a year, it was like a grant, 20% of what everybody else pays. That's great. But a new state law just came down that said now you have to live in the county for 5 years before you can qualify for that. So they're gonna get some money from you before they give you the tax break. Why did that happen? Because other counties were getting mad that seniors were moving to these counties and losing the tax base because Cherokee County is 20% of the tax that Bartow was. You move to Lake Arrowhead, which is arguably marketed as a senior-friendly community, and you don't get a tax break? It seems silly, right? Finally, our legislature did something really cool though. In March, they voted to enact what's called a transfer on death deed. Remember earlier whenever we talked about your bank account that could have a transfer on death? The advantage of that for your bank account was that your kids were on your bank account. It wasn't an asset of theirs. We can now do that with deeds. You can record a deed that's called a transfer on death deed, often called a T.O.D., that says while you're alive, the house is 100% your house. Whenever you die, without going through probate, whoever you listed as that T.O.D. beneficiary now can get that house by just signing one piece of paper and showing a death certificate. That's pretty cool. When do we not want to use this? If we have multiple children, it becomes problematic. If we have 3 kids, do we think that they're going to split the house equally? Your parents will say yes. The siblings will say, yeah, but my sister's going to do X, Y, Z. And so one of the big problems that we run into in states that have had this transfer on death deed for a while is that if the people that inherit it fight, you're still back in court in what's called a partition action, which is where the court says we're going to force the sale because one of the 3 kids wants to sell. That's going to come down the pipeline. The other thing is it won't be except for one-time distribution. So a lot of times people will focus on having a trust to avoid probate. If you have a trust to avoid probate, you can make distributions over time. You still get to step up a basis at the end, and you don't have the partition problem. The problem is the trust is more expensive than this is. So for people that truly have simple plans, a T.O.D. could be helpful. Whenever we start talking about our aging parents, one of the things that we have to remember is where you can have a trust that protects that home from Medicaid. On a transfer on death deed, Medicaid still gets paid back from this before the kids get to assume the house. So say that mom goes into a nursing home for 5 months before she passes away, and then it says T.O.D. on her house to the 3 kids. The 3 kids will have to come up with the money to reimburse the state for what Medicaid paid, or they're gonna have to sell the house, then the state gets it through their lane. But if you really do just have a simple plan, 1 kid or 2 kids or 3 kids that you really think aren't gonna fight, this is a very economical way to avoid probate and still get those tax benefits that you used to get through just a trust. So we went through our 4 tools. We talked about a will. We talked about T.O.D. I'm going to open it up for Q&A. Who has any questions for me?
Okay, Todd, you get a stepped up basis on the home?
Absolutely. That's one of the coolest things. So the gentleman's question, just because this is being recorded, on T.O.D., do you get the full step up in basis whenever the kids get it? The answer is yes. That's one of the coolest things about this. Is say that you had your house that you bought for 200, it's worth 500, your kids inherited at 500 basis because you died. If they sell it the next day for 501, they only pay tax on the 1. That it?
Do you have to have a, oh, sorry. Do you have to have a separate one for transportation via the
No. The lady's question was for the pulse, the physician's order for life-saving treatment. Do I need to have a different one for transportation than I have like for at my assisted living or at my house? There's an issue that always comes up with DNRs or pulse, which is EMS, when in doubt, is going to try and revitalize you. They're gonna try and save your life. And again, this is where lawyers ruin stuff. If EMS saves you, there is zero liability to them. If they let you die because they were mistaken, there's a lot of liability for them. And so they will generally try and say, when in doubt, revive you. There are bracelets, pendants that you can get to notify them that these are the choices that you've made. And then the second best thing is, especially if you're at your home, you put your pulse on the side of the refrigerator. Every first responder is trained to check your refrigerator side if you have one. A lot of times, if you go into like an assisted living, it could even be like posted on the bed, like the headboard. It just depends on how serious you want to take. But EMS is generally going to default to, let's try and keep this person alive. In fact,
You mentioned the two different powertrains, financial and medical, so in the event like one person be designated, each one's have two separate POAs, like, there's one can impact the other, and you make a medical decision that obviously has financial effects too. How do those two dynamics work out? Is it better to have one person than people?
this is a question that we go through daily in my firm, because often you'll have somebody that maybe is a little bit better at medical decision-making or a little bit more kind-hearted, and then you got somebody that's good at finance. And then the question always becomes, how is that balanced? The advanced healthcare directive or the medical power of attorney says in most of them that that person has the authority to incur bills. But we're in America. In America, if you don't pay, you don't get services. And so I would argue that the financial power of attorney is always a stronger power, because no matter what the medical power of attorney person wants to do, if they don't have the money to pay for it, it doesn't get done. Does that answer your question?
I mean, it's kind of an open-ended question, but if you don't have the finances, like medical power of attorney, in theory, you can't make the decision if the finances are there. If they do, if the financials are there, let's say the financial power of attorney said, hey, this is a bad decision, who can one override the other, I guess, is the first one.
Technically, medical wins if you bring it in front of a judge. The problem again is it's usually a speed related thing. So usually where we see this come up the most is with placement. So you're going around, you're looking at all these different types of communities where you might move your parents into. And maybe your brother is the financial and you're the medical, and you say, I love this place that is $7,200 a month. And your brother says, I like this one that's $5,200 more. Usually, you kind of mediate it out inside the family and probably go with the cheaper one unless you can really convince them what the benefits were. And it depends on what their income and budget were for your parents too. If you take it to court, the medical power of attorney wins.
Right, so I mean, in theory, like the civil just need to negotiate this kind of come.
Yeah, especially, we always suggest that you have them the same to avoid that kind of dynamic. I understand that that's not applicable in every family though. A lot of times, the medical power of attorney would just be the closest one. Or somebody with a medical background. And the financial one is usually the oldest or the most financially successful.
So when would you recommend a trust?
I think the trusts get overused. But there's some really good applications for it. The number one reason to use a trust is if it fits what you really want to have happen to your stuff. There's two main types of trusts. One's called revocable and one's called irrevocable. Irrevocable is a scary word for most people because they feel like it means non-changeable. Those are not actually synonyms. You can have an irrevocable trust that after July of 2017, because the laws changed, you can change with a phone call. So what's the difference between a revocable and an irrevocable trust? An irrevocable trust protects against future creditors. That includes hospital bills, unsecured debts like credit cards, lawsuits, things like that. So say that you have $400,000 of equity in your home, and that's your main asset. My suggestion for most people in that situation is an irrevocable trust because it protects that home equity no matter what. When is that a bad plan? If you got somebody that's day trading every day, that's not a good solution for them, or at least putting those funds that they day trade with in there isn't a good solution. On an irrevocable trust, you still receive the income as the grantor or the person that created the trust in most cases. But you can't go in and take the principal out as easily as you can with a revocable trust. So why would anybody want a revocable trust? Before Todd, it was because you wanted the tax base step up and you wanted to avoid probate. After Todd is available in Georgia, the main difference is if you want to give designations to multiple people or grandkids, or you want to give it at different times. I'm not a big fan of wills because wills in Georgia always go through probate court. So in other states, a will can avoid probate court, but in Georgia, your will only directs the probate court what to do. So you're still in probate even if you have a will. And so that's often where somebody will jump up to a trust. Now that we have Todd, it might be worth seeing if Todd or transfer on death deed and then beneficiaries on your financial accounts accomplishes a good enough plan. For some people it will, and for some people it won't. It's really an individual thing.
So once somebody has all these documents in place, how often does the laws change where you have to go back, revisit the documents you've already created? And once the laws do change, do you guys keep a record of what individuals have already done? So you can call them and say, Mrs. Smith, law has changed on this. You might want to look at this document and update it.
Yeah, I'm going to answer two questions there because it brought up one in my mind that I think is important. First, where do you keep this stuff? It's not in your safety deposit box. It's not in your fireproof safe at home, unless you've also gotten digital copies or PDFs and given those to your agent. So like whenever I work with families, we give you like a thumb drive that has all the PDFs on it. We just rolled out a new portal where they're actually accessible to families 24/7 through their phone app. But we suggest that the kids save it to like a Google Drive so that if you get that call that mom or dad is on their way to the hospital, you're not going to go home and rifle through their stuff or even go to your home because you kept it at your house. You're going to head to north side because you need to be there. Ever since 2017, digital copies in Georgia of the Advanced Healthcare Directive or the Power of Attorney, as long as they say that the digital copies are just as good as the original, are just as good as the original. So that's really cool. Your follow-up question, the one you wanted to ask, is how often does this stuff need updated? I don't want to be judgy, but if we're talking about for you guys as parents, it's probably one and done. It probably doesn't need to be updated. Sometimes the power of attorney will age out a little bit. So often attorneys try and make money by having you come in for a review or a maintenance program, or come sit down with me again and pay me a couple $100. We don't do that because I don't see the value in it. We know that whenever people get this done for the age group that I help, this is probably or hopefully the last time we do it. It doesn't mean that it's not changeable, but it doesn't require changes. Certain financial institutions will try and claim that a power of attorney over 3 years old is not required to be accepted. In July of 2017, our legislature did a really cool thing that said they can't pull that stunt with you. Because think about it, if you go and get a power of attorney for dad, 3 years later, he has dementia, he can't sign again. So now it's just garbage? No. In Georgia, there's a thing that you can sign called a certificate of authenticity or a certificate of authorization or a certified power of attorney. It's changed its name over the last 5 years. But it's just a piece of paper that you sign that says, this power of attorney is still valid to the best of my knowledge. And if the bank doesn't accept it after 5 days, they have to pay my attorney's fees whenever I go to a judge to get the judge to say, you need to accept this. This law changed in July of 2017. I have been wishing that I could find a bank that would violate that 5-day rule, because I really like to be able to sell stuff and get paid that I didn't have to sell. I've not been able to find one that will go past the 5 days. And we've done well over 6,000 things.
I actually had a trust done by Nelson. And one of the things that we did, I think it's because of dealing with the senior industry, which really made me very aware of it, was that some stuff that I put in there, my son is my 22-year-old is the person who does that. But we've also threatened him that if he does something we don't like, we can fire him as the administrator in essence. But we also kept some bank accounts out because of working. So it would, for us, it's actually, I'm still finishing up the very end of mine right now. But for me, it gives me peace of mind that I do not ever have to worry about this again, if something happens to us.
Yeah, it's very individualized. So really you want your law firm or your attorney to sit with you and go for your individual accounts and make sure that the plan is really tailored for you. It's not a one-size-fits-all thing.
What is the main difference between an elder care law attorney and an estate planning attorney?
Elder care law has a worse name. Nobody's elder. I have 7 clients over 100. They'll tell me they aren't old. It's just what lawyers call it, but really the big difference is focusing on autonomy and benefit qualification during your life. Estate planning prior to 2011 was really just for high net worth individuals. Prior to 2011, somebody that had $3 million was considered high net worth. What do we think that number is today? $24 million. And so estate planning used to be more focused about death taxes because the IRS taxes your taxable death tax estate part at 40%. The reality is that in the last 13, 14 years, estate planning for tax purposes has died. Because the people that have more than $24–25 million are doing very, very complicated schemes to not pay that tax. And the people that have $9 million don't pay any death tax. That's kind of crazy to think about, right? Most of us in this room have no idea what it would look like for us to have $9 million, let alone for us and our spouse to have $20 million together. And we're told all of our lives to worry about these death taxes. And most of us will never get there. I mean, if you got $30 million, come get me afterwards. I want to fly on your jet. Let's go on your boat. Let's be cool together. But just the reality is that whole line of estate planning business to avoid death taxes doesn't really exist. And so they've really tried to morph it into 2 different things. First, for people that have minor children, you still do need to have a will to nominate, like if you got hit by a bus, who's going to be the guardian of your kid. Those aren't elder care lawyer people. My average client age is 72. We work with older people, we work with younger people, but really we don't go that much under 55, except for people that like we kind of know, or like if we do a parents plan, maybe we'll do their kids or something like that. But estate planning right now is generally for minor children planning, or it gives you these 4 tools plus a will. If you're in your 30s and you're worried about how do I do this most cost effectively, there's a place called trustandwill.com. You guys saw them in the Super Bowl, you probably get Facebook ads for them. It's $600. That ain't a bad plan, guys. It doesn't protect assets, but it will get you what you need for that stage of life.
Josh, can you explain, like, if you have normal POA, how does that compare to the need to get guardianship or?
I am over time, but I'm happy to answer this question if you guys want to hear the answer. The question she's asking is, I go through this planning. I get somebody who's nominated to make medical decisions for me, and I get somebody who's nominated to make financial decisions for me. What happens if I need the next step? That next step is called a guardianship over the medical decisions and a conservatorship over the financial decisions. These are both court litigation, going in front of a judge type things. Often in the senior community even, you hear people say, Dad's got a touch of dementia. Why don't you go get a guardianship over him? We do way more guardianships than I want to because I like going to trial. But I think it's horrible for the families. So let's just talk about the practical aspects. You want to get a guardianship over your parents because you couldn't have this conversation, or they didn't want to have it, or something happened, they didn't ever sign it. Now they're doing crazy stuff. Literally this morning, I had a husband come in. His wife has donated over $300,000 this year to the Win Red political campaign. Bad news is they don't have that kind of money. So he's like, I talked to her doctor. The doctor wrote a note that said she can't handle her finances, which, like we talked about earlier, is hard to get, so she's pretty far gone. He wants to get a conservatorship over her because they're going broke. He won't really enjoy doing it though, because he has to go file a petition in the probate court of the county, which is now public record. With the internet, anybody can find it. Worse, there's a social worker that's going to come out and evaluate her. They live together. How do you think that conversation goes? After that, she gets appointed an attorney that represents her interests in this case, and he's got to pay for it. Then they're going to go in front of the judge, and he's going to say things about her that are true, but she may not remember. If anybody's ever dealt with somebody that has cognitive impairment, the problem is he's going to go up there on the stand and say, in one day, she took out 6 withdrawals of over $40,000 to donate to this political campaign. She makes less than $2,500 a month. That's grounds for a conservatorship. What if she doesn't remember doing that? She's going to think he's a liar. One of the worst cases I had was a son that was getting a guardianship over his mom, where she was 91 years old and would streak through the neighborhood because she was living in his basement apartment. She did not recall ever doing that. While we're in the middle of court, she lashes out where the sheriff has to restrain this 91-year-old lady from beating up her son because she thinks he's lying. She got to the courthouse because he drove her there. So even after the hearing, they have to get in the same car and drive back home. So I'm not a big fan of this. It is really, really hard on the families. Let's talk about it differently. So you do have these things in place. Part of your advanced healthcare directive has a paragraph in there that says, if I need a guardian, I want it to be this person. part of your financial power of attorney has a paragraph in it that says, if I need a conservator, I want it to be this person. What does that do? It makes it so that if you do have to go get a guardianship conservatorship, the attorney that represents your parent probably waives their appearance in court, which means you don't have to do this in front of them. So having this stuff in place, even if you get to that point, helps. But then let's ask the question is, if I have this stuff in place, how do I get there? It's really one issue. We talked about a power of attorney, whether for finance or medical, does not take any power away from the person that granted you that authority. So if that person is then going and doing crazy spending or crazy health stuff, you have to go get a conservatorship still. You have to go get a guardianship still. Most often, this is because of severe cognitive impairment. It's where mom or dad is getting scammed. If you look at your parents' phone and it's just ringing constantly, it's because they picked up unknown numbers and then those numbers have been sold. A lot of people don't understand like where the phrase marked man came from. It's actually off the New Jersey boardwalk. Back whenever they had carnies and little people that would like do all these games, people would put chalk on their hands. If they saw a sucker, they'd pat him on the back. And whenever they went from little game to little game, the people that were running those games knew who the sucker was and who they could get the money out of. The modern version of that is somebody picks up a phone call that's unknown, and then it goes click. All of us have done this. That's usually a foreign entity that collects phone numbers and sells them, saying, this is a list of phone numbers that people will pick up even if they don't know. That's why senior phones just ring constantly. It's because once you do it once, you're gonna get more, and you're gonna get more. And then all of a sudden, we get lonely. Maybe as children, we're not visiting as much as we want to. Somebody's on the other side of that phone, you get scammed. You get scammed more than once, probably time for a conservatorship. Right? That's where, even if you have a power of attorney, you might select a conservatorship to remove access from accounts. You think about like a qualified account, like an IRA. You guys have invested in your IRA, your parents have invested in their 401k, IRA, anything like that, without ever paying the income tax. If you notice that they're taking big chunks of money out of those what are called qualified funds or pre-tax investments, you need to have a serious conversation. Because at the end of the year, if that money's gone, there could still be a big tax bill. You want to avoid having the IRS as a creditor. You want to avoid the IRS as a debtor. A lot of times that's what drives a conservatorship. But most people that have an advanced healthcare directive and have a POA will never have to get a guardianship conservatorship.